said by Nelson Mandela, education is the most powerful tool that is given in your hands through which you can change the world. Education is one thing that no one can take away from you. Hello and welcome everyone to the Polity Primer series of Drishti IAS English. My name is Pragya. In our today's episode, we are going to discuss the 86th Constitutional Amendment Act, which provided us with right to education as a fundamental right. So in this discussion, we are firstly going to study about the background of the evolution of right to education in India. Then we are also going to understand the landmark judgments delivered by Honorable Supreme Court, which made right to education as a fundamental right. And then we are also going to see what is the 86th Constitutional Amendment and the constitutional changes that have been introduced by the 86th Constitutional Amendment. And lastly, we are going to discuss some of the important questions which are very important from the perspective of your prelims examination. So if I talk about the evolution of the right to education in India, so see, when the constitution was imposed, the right to education was inherently not a fundamental right. Rather, it was a part of the directive principles of state policy. Directive principles of state policy. Under Article 45. So, Article 45 basically promised free and compulsory education for all children until they completed the age of 14 years. And this was to be attained 10 years after the enforcement of the Constitution. So, basically, a timeline of 10 years was granted to achieve the right to education below 14 years. And then in the 1968, a very important national commission known as the Kothari Commission was constituted by the government of India to look to recommend the reform in the education system. And this Kothari Commission had its special focus on girls' education. So basically, this was the very first national commission that was constituted to promote education in India. And why does it focus on girls' education? Because after independence also the parents were not sending their girls to school. Okay, so the girls' education was still a far-fetched reality. And that is why this commission, the recommendations of this commission, laid special focus on the girls' education. And then came the Sarva Shiksha Abhiyan. And this is a very famous and a flagship scheme introduced by the government of India in the year 2001 to 2002. And it had its main focus on universal elementary education. Universal elementary education. So this was a flagship scheme that was launched by the government of India. Moving forward, let us discuss the important landmark decisions given by the Honorable Supreme Court of India, which finally made right to education as a fundamental right. So the very first landmark judgment in this regard is the judgment delivered by the Honorable Supreme Court of India in the case of Mohini Jain versus State of Karnataka. State of Karnataka. And in this case, the Honorable Supreme Court recognized the right to education as a fundamental right, which essentially flows from Article 21 of our Indian Constitution. And Article 21 talks about right to life and personal liberty. So the Honorable Supreme Court in the Mohini Jain versus State of Karnataka held that right to education flows from right to life and forms an important component of living a dignified life, because without right to education, you will not be able to avail your other fundamental rights. You will not be aware about right to equality. You will not be aware about right to livelihood, right to freedom of speech and expression. Okay, so for all of this you need elementary education, and that is why the Supreme Court said that it flows from Article 21 of our Indian Constitution, because Article 21 of our Indian Constitution says that right to life does not mean a mere animalistic existence. It means living a dignified life. Reading cumulatively, Article 21 along with the directive principles contained in Article 38, 39 clauses 41 and 45. The court opined that it becomes clear that the framers of the Constitution made it obligatory for the state to provide education for its citizens. And we saw that yes, a 10-year timeline was given by the framers of the Constitution to enforce Article 45, which promised free and compulsory education to all of the citizens in India below 14 years of age. Moving forward, the court in the case of Unni Krishnan versus State of Andhra Pradesh, and this judgment was delivered by the Honorable Supreme Court in the year 1993. So see, in Mohini Jain versus State of Karnataka, the Honorable Supreme Court gave a very expansive scope to right to education. It said that the state was obligated to provide right to education on all levels. On all levels. That means from primary to higher level. From primary to higher level. So this was a very expansive interpretation that was given to the right to education in the Mohini Jain versus State of Karnataka. Okay, and that is why this 5 judges bench or the constitution bench was created, because the state said that no, we do not have the appropriate economic resources. We can provide primary education, but on all levels it would be very difficult for us to provide right to education. And that is why the judgment of Mohini Jain versus State of Karnataka was reconsidered by the Honorable Supreme Court in the case of Unni Krishnan versus State of Andhra Pradesh. And in this case also, the Supreme Court reiterated the position that having regard to the fundamental significance of education to the life of an individual and the nation, the right to education is implicit in and flows from the right to life guaranteed by Article 21 of our Indian Constitution. So this proposition that was evolved by the Honorable Supreme Court in the previous decision of Mohini Jain versus State of Karnataka was reiterated by the Honorable Supreme Court in the Unni Krishnan case. But the court said that the parameters of this right, which is not absolute, have to be determined in the light of the directive principles contained in Articles 41, 45 and 46. So basically, it limited the scope of right to education. It said that it cannot be made as an absolute right. The state is not bound to provide you education on all levels. Yes, for primary levels, you can ask the state, but on higher levels, it is your responsibility to educate yourself. The state can only help you if it is financially and economically stable to help you. Moving forward, the court limited the state's obligation to provide educational facilities on following 2 grounds. That is, every citizen has a right to free education until he completes the age of 14 years, because this was originally envisaged by the framers of our Indian Constitution. Then beyond that, the state to obligation to provide education is subject to the limits of the economic capacity and development of the state. So basically, it made right to education as a fundamental right, but it limited its scope. Now, moving forward, let us discuss the 86th Constitutional Amendment Act. So after the Supreme Court judgment in the Unni Krishnan case, this 86th Constitutional Amendment was brought by the Parliament of India in the year 2001. The Constitution 86th Amendment Act 2002 inserted 3 amendments to provide for the education and welfare of children. So firstly, it inserted Article 21A in our Indian Constitution, and Article 21A casts an obligation upon the state to provide free and compulsory education to all children of the age of 6 to 14 years in such manner as the state may by law determine. So basically now, free and compulsory education from the age groups of 6 to 14 years is a fundamental right that has been ensured by Article 21A of our Indian Constitution. Moving forward, the 86th Amendment also substituted a new article for the original Article 45, which dealt with right to education, which provides that the state shall endeavor to provide early childhood care and education for all children until they complete the age of 6 years. Because after 6 years, it is your fundamental right as per Article 21A. Okay, but before 6 years also, the state has this obligation to provide you with early childhood care and education. Then it also inserted Article 51 Clause A, which enjoins a parent or guardian to provide opportunities for education to his child, or as the case may be, ward between the age of 6 and 14 years. So not only the state is liable, the parents and guardians are also liable to provide you with your fundamental right to education between 6 to 14 years. And we also know that we also have a dedicated act that is known as the Right to Education Act. 2009. We'll be discussing this act in detail when we'll be discussing the important acts in this series. Okay. So Right to Education Act has also been enacted by the Parliament of India to provide you with education. So with this, we come to a conclusion of our today's session. We have seen that yes, previously the right to education was a part of the directive principles of state policy. Then we constituted various commissions which laid down the importance of education. Okay, then we had the Sarv Shiksha Abhiyan. Then we saw that the importance of right to education was observed by the Honorable Supreme Court in various landmark decisions, including Mohini Jain and the Unni Krishnan decision. Okay. Then we saw that finally in the year 2002, the 86th Constitutional Amendment Act was passed and it made three changes. Firstly, it inserted Article 21A in our Indian Constitution. Then it also modified Article 45 and it also added Article 51 Clause A in the Indian Constitution. Now let us discuss a practice question which I asked you in my previous session. So the question is, consider the following statements about 85th Constitutional Amendment. The statement number 1 was, it modified Article 16 Clause 4A in the Indian Constitution. Your statement number 2 was, it added the provisions related to consequential seniority of SC and ST candidates. So which of these statements given above is are correct? Your options were, option A was 1 only, option B was 2 only, option C was both 1 and 2, and option D was none of the above. So your correct answer will be option C. Both of these statements are correct, and if you did not know the answer, you can watch that video to understand why it is the correct answer. Now let us discuss the practice questions from our today's session. So the question is, consider the following statements. So statement number 1 is, right to education is a fundamental right under Article 21 of the Indian Constitution. Statement number 2 is, it is also basic human rights under the Universal Declaration of Human Rights. So which of these statements given above is are correct? Your options are, option A is 1 only, option B is 2 only, option C is both 1 and 2, and option D is none of the above. So a correct answer will be option 2 only. Most of you will be confused between Article 21 and Article 21A. So remember that after the 86th Amendment Act, okay, Article 21A is the article which provides you your fundamental right to education. Okay, and yes, right to education is also a basic human right under Article 26 of UDHR. Now let us proceed to discuss the next question. So the question is, originally right to education was in part 4 of the Constitution under which article? So options are, option A is Article 38, option B is Article 45, option C is Article 39, and option D is Article 14. And this answer will be given by you to me in the comment box below. I hope this session was insightful for you. If you have any feedback regarding this session, kindly drop it in the comment box below. If you liked the today's discussion and found it to be helpful, Kindly like the video and subscribe to our channel for more such interesting updates. Thank you.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.